Okay, now that we've talked about monetary damages, we move to that next topic of defenses. There are certain excuses or defenses for non-performance. A court can excuse a party's non-performance for certain reasons. And whenever we talk about a defense in the law, what we're really talking about is an assertion that even though everything you've said is true, you cannot recover because of a good reason. And that good reason is what's known as a defense. Now, the defense that virtually all of you are going to be familiar with is the idea of a statute of limitations. You know that when you are harmed by a breach of contract, there's a certain amount of time in which you must bring your case. The same for torts. If you are walking across Hall of Fame Boulevard and someone strikes you, runs a red light and strikes you with their vehicle, you have a right to compensation. But there's a statute of limitations attached to that. And in Oklahoma, the statute of limitations for a tort is 2 years. Meaning that if you sue within that 2-year period, you can be compensated. If, however, you wait 2 hours in a day, you have lost your right to compensation. You've lost your cause of action. Your cause of action disappears. You cannot recover that. So even though everything you've said is true, the party ran the red light, they were speeding, they were intoxicated at the time, they weren't looking where they were going, they were texting, all of those may be true, but if you waited too long, if I can assert the defense of statute of limitations, you don't get to recover. So this is why I call it an excuse, which is to say, under certain circumstances, I can be excused from performance. A breach of contract case, the statute of limitations is 4 years in the state of Oklahoma. If you fail to bring a claim within 4 years, you cannot recover on that contract, even though the other party breached. They failed to ship the goods or they failed to pay for the goods. Now, what are the excuses set out in the contract or in the CISG? First of all, impossibility. Impossibility of performance usually arises when the subject matter of the contract is no longer available. For instance, if the subject matter of the contract, the goods, were destroyed in a fire, it is impossible to comply because the goods were destroyed. Yes, I was supposed to provide you the goods on December 15th. I did not do so because the goods were destroyed on December 14th. It was impossible to perform. A court can excuse that situation. Now, impossibility could be a gray area, right? So impossibility of performance, again, you as a defendant, you have to assert that it was impossible for you to perform, impossible for you to comply with the terms of the contract. Frustration of purpose, meaning the point of the contract is lost. The reason that we entered into the contract is lost. If there were technical goods and then the technical goods become no longer useful, one could argue frustration. I'm not going to really cover that on your test. That's a very gray area. The third excuse or exemption or defense that we really need to focus on is what we call impediment beyond control. And CISG Article 79 says that a party is not liable for a failure to perform any obligations if it was due to an impediment beyond control, meaning beyond the control of the parties. If something happened that prevented performance. Now, impediment beyond control can be a broad area, right? Courts do not like to grant this defense because there's the argument that this should have been considered when entering into the contract. So, for instance, that Suez Canal case, wherein a cargo ship, a container ship, was unable to transit through the Suez Canal because it was blocked. It had to go the long way around and went all the way around Africa. It sued for the difference in the cost between what it expected to obtain traveling through the Suez Canal and what it actually obtained, which is traveling around the Cape of Good Hope at the bottom of Africa. In that case, the court said, you should have thought about that. It's not an impediment beyond your control because you could have contracted for that. If there is a contract to sell certain oil at $50 a barrel, and a war breaks out in the Middle East, and suddenly the cost of the barrel of oil shoots up, and the seller wishes to breach, they may claim impediment beyond control. They cannot provide the goods as they were expected to. So impediment beyond control isn't a defense. It is an excuse for non-performance, but it is one that is difficult to recover. For this impediment beyond the control to apply, we must show that the impediment was not foreseeable at the time of the contract. We must show that the impediment was unavoidable, and we must give notice to the other party of the impediment and its effect on the contract. I had a situation once when I was practicing, and I represented a construction company that was building a church, a mega church in New Orleans, Louisiana. The construction had started, the framework had been set up, the area cleared, the framework up. Nevertheless, there's a lot left to finish when Hurricane Katrina struck. Hurricane Katrina shut down New Orleans for about 6 months, and therefore we were unable to comply with our obligations under the contract. My client was unable to comply. They sued us in court. You promised to finish this by September 15th, and you didn't finish it until January 15th. We want to argue that that was unavoidable. We could not comply because New Orleans was closed. But the question that came up was it foreseeable? A hurricane that strikes New Orleans in August, maybe you could have foreseen that. Maybe the resulting damage was unforeseeable. Maybe the hurricane was foreseeable. In any event, we never got an answer because we settled that case. But that's what we're talking about. It's always going to be a gray area in which one party is going to say comply with the contract, and the other party is going to say it's simply too difficult to comply with the contract.